into something completely different. This is the reality of federal obstruction statutes. Under 18 United States Code, sections 1519, you don't need to personally shred a single document. Directing it, knowing about it, and failing to intervene is enough. The legal complaint also traces the financial angle: $127 million. Money set aside for a special task force focused on corporate fraud was quietly shifted to another department back in November. No official paperwork, no notice to Congress. Why is this significant? Because the Gibson investigation, the one they were allegedly trying to conceal, was examining 3 firms tied to political contributors. Page 163 details it. Blackwell Industries, for $0.2 million to the inauguration fund. Crestpoint Capital, $2.8 million to the super PAC. Meridian Holdings, $1.7 million in bundled donations. That totals $8.7 million in political gifts. $127 million in investigative resources pulled back. Connect the dots. The consequences are already unfolding. The Bureau opened its own separate investigation last Friday. The House Oversight Committee has called urgent hearings for next week. 2 more Justice Department staffers retained private legal representation yesterday. All of this within 72 hours of the document being made public. That's merely the initial level of documentation. There's much more. Subscribe to get the complete analysis. I'm examining each document as it's released. This situation is developing rapidly. All right, but to be equitable, the opposing perspective has merit. Several points, actually. Conservative legal commentators argue this represents the politicization of the justice system. And frankly, parts of that reasoning are valid. Their viewpoint: first, the whistleblower was appointed during the Biden administration. 19 years at DOJ, certainly, but the final 4 years under the prior administration. That's pertinent information. Second, the Senate Judiciary Committee, which requested these files, is controlled by Democrats. The release comes just before the midterm elections. One can understand why some are skeptical. Third, and this is their most compelling argument, the actual charges filed on Saturday target 3 specific officials, not Pam Bondi. The phrase "AG is aware" doesn't detail what exactly she was aware of. It could be interpreted in various ways. Tom Fitton, head of Judicial Watch, stated it this way: "This is a political attack masquerading as legal action. I don't endorse all of it, but it's not inconsequential." That's their argument. The whistleblower's political contributions, $2,700 to Biden in 2020. The timing aligning with election cycles. The fact that Bondi isn't directly charged. Even Jonathan Turley, a legal scholar hardly known for partisanship, concedes that proof of direct involvement by the Attorney General remains indirect. That's a George Washington University law professor who testified during impeachment proceedings. He's not biased for any side. Listen, my role isn't to declare who is correct. The prosecution's case, the proof backs it. Erased files, an orchestrated concealment, a financial trail. The defense's case, there's proof too. Political operatives, biased motivations, vague wording. Both perspectives can be valid at the same time. That's what creates the legal complexity here. And let's be honest about another factor. Bondi's supporters highlight her absence from crucial meetings. The calendar logs, which they provided without a court order, place her in Phoenix at a law enforcement gathering during 2 of the dates referenced in the legal document. That's significant. You can't orchestrate a cover-up from a stage in Arizona. Her legal representatives also argue the AG is aware communication is being misinterpreted. The entire conversation thread, they assert, concerned an unrelated issue. They are requesting the complete message history be made public. Fair argument. Context is crucial. Here's what even critics accept. The proof against the 3 indicted individuals is substantial. Hardly anyone contests that. The unresolved issue is the extent of higher authority, and that question remains unresolved. Senator Lindsey Graham commented on Sunday, "Allow the procedure to unfold. Drawing conclusions prematurely benefits no one." Also a fair point. What I can definitely show you is what the documents reveal, and they reveal coordination. They reveal purpose. They reveal a systematic approach. Whether Bondi orchestrated it, was aware of it, or was intentionally left uniformed. That's what the subsequent stage will determine. Speaking of which, this didn't emerge unexpectedly. A quick background. 6 months ago, initial stories emerged concerning unusual personnel shifts at DOJ, veteran prosecutors moved, probes quietly terminated. Nothing definitive, but trends forming. 3 months ago, the Gibson inquiry is referenced in a leaked internal communication, the first time the public heard that designation. DOJ claims it's an internal HR issue. Not accurate. 8 weeks ago, a congressional subpoena is issued. DOJ confirms the files exist, but asserts executive privilege. 6 weeks ago, a federal judge rejects the privilege claim. An appeal is filed the same day. 3 weeks ago, the appeal is denied. Files are ordered to be turned over. February 11th, chaos. An individual inside, reportedly from Whitmore's office, alerted investigators about the planned data erasure. They managed to secure backup drives just before they were scheduled to be erased. A veteran DOJ attorney speaking unofficially to the Washington Post. People were genuinely terrified. You don't last 20 years here by being foolish. What happened? Panic. Bad decisions compounding. A sequence. Information is sought. Delay strategies used. Proof quietly eliminated. A deceptive story is built. The deceptive story falls apart. Each time someone assumed they were safe until February 11th, live television, 14 million viewers, Senator Whitehouse displaying a document Bondi's office insisted wasn't there. Her expression revealed everything. See where this is headed? Engage with this video. The algorithm determines visibility. Your interaction helps this reach individuals who genuinely seek to comprehend the situation. It's more impactful than you might realize. Wednesday, February 11th, 10:47 a.m. Eastern Time. Here's the sequence. Bondi is testifying 3 hours in. Standard material, largely oversight questions, budget matters, policy focuses. Then Senator Sheldon Whitehouse brings out a manila envelope. Attorney General Bondi, can you identify this document? I don't recognize it. It's from your department dated November 3rd, 2025. Your signature appears on page 4. The room fell silent. What ensued? A 7-minute pause called by the committee leader. Bondi's main counsel speaks urgently to her. She comes back and asserts executive privilege regarding 4 distinct inquiries. Whitehouse adds 31 pages to the official congressional record. 23 minutes. That quickly. Now, what everyone overlooked. While cameras focused on Bondi's misstep, another event occurred out of sight. 2 FBI agents exited the hearing room, verified by C-SPAN footage at 11:14 a.m. They proceeded straight to DOJ headquarters. By 3 p.m. that day, building entry records indicate unusual access in the records department. After-hours badge entries. 7 personnel who don't typically work that level. Then the data center in Delaware is erased. 11:47 p.m. But the whistleblower had already obtained duplicates. The FBI's reaction, a sealed warrant request submitted February 13th, 2 days later, wasn't impulsive, it was deliberate. They waited for DOJ to act, then recorded everything. You can observe this in the legal timeline. They were aware, they observed, they permitted the action to occur to demonstrate criminal intent. This is where it becomes compelling. The 3 officials charged Saturday weren't the main targets. They are now cooperating witnesses. That's a standard prosecutorial tactic. Turn the mid-level individuals. Move towards the top. A traditional method, though typically not directed at a current attorney general. Stay with me. What I reveal next alters the entire perspective. Share your forecast in the comments section. Who do you anticipate will be charged subsequently? Then continue viewing. Check if you're accurate. What are legal authorities actually stating? A former federal prosecutor from the Southern District of New York with 22 years of experience. The AG is aware communication is damning. In any typical scenario, that indicates awareness of wrongdoing. Simply put, when an individual ensures the superior is informed before erasing proof, prosecutors view that as evidence of the superior's participation. Another expert, a constitutional law professor at Yale. Executive privilege has boundaries. It doesn't shield criminal behavior. Nixon established that 5 decades ago. Key point here. Bondi cannot use privilege as a shield if illegal acts occurred. The Supreme Court determined this in 1974. Here's what's noteworthy. Even former DOJ officials from Republican presidencies acknowledge the timing of the data erasure is highly suspicious. You don't erase servers during active legal proceedings unless you're concealing something. That's a former deputy AG under George W. Bush, not a liberal commentator. When opposing sides concur on something, take notice. A broad agreement exists. The 3 charged individuals have few legal alternatives. Immunity agreements are probable in return for testimony. The investigation's trajectory is obvious. It's moving upward, not sideways. A criminal defense attorney who represented Enron officials stated, "I've observed this strategy previously. Mid-level personnel are pressured. They either accept responsibility or they provide information. Most individuals provide information. That's where experts land. The dispute isn't about whether crimes happened. It's about the extent of involvement up the hierarchy." A former assistant U.S. attorney, now in private practice. Following the evidence wherever it leads sounds admirable, but when it leads to the Attorney General's office, you must have an airtight case. No mistakes allowed. Interpretation. Prosecutors recognize the high risk. If they're pursuing this, they are confident they can demonstrate it. No one targets a sitting AG without absolute certainty. Helpful analysis. Hit the like button. I invest time examining these legal documents so you don't have to. That like button signals to the algorithm this is significant. Takes a moment. Provides substantial assistance. Why should this matter to you? Honestly, how this impacts ordinary people. Your tax contributions. That $127 million in enforcement resources. Your funds. It was intended to probe corporate fraud, the kind that impacts retirement accounts, pension funds, small-scale investors. Instead, it was diverted to a department with no ongoing investigations. If you possess a 401k focus, 3 of the firms that avoided scrutiny, Blackwell, Crestpoint, Meridian, all have ties to municipal bond markets. Your city's infrastructure bonds might be connected. Your state retirement fund definitely is. CalPERS alone holds $340 million across those companies. This isn't guesswork, it's public financial disclosure. Accessible to anyone. Legal precedent. This establishes a benchmark regarding responsibility. If an attorney general can authorize evidence destruction without repercussions, the next one will act more aggressively. A brief illustration. Imagine you're ever subpoenaed for a business conflict, divorce, etc. You erase some emails you shouldn't have. What are the consequences for you? Obstruction accusations, contempt, potential incarceration. What happens when the DOJ performs the same act? Apparently, we're still determining that. That disparity is significant. It determines whether legal standards apply uniformly. Who is impacted currently? At this moment, 147 DOJ personnel have secured personal legal representation. That is unusual. The department is confronting a legitimacy crisis. Active cases. Approximately 8,400 current federal prosecutions all confront potential defense challenges. Your Honor, how can the DOJ prosecute obstruction when they just committed it? That challenge is forthcoming. Defense lawyers are already composing motions. This impacts everyone with an ongoing federal case. Those accused, those harmed, those providing testimony. The uncomfortable aspect no one wants to address. If the nation's top law enforcement officer is implicated in obstruction, even indirectly, it taints everything. Every prosecution, every conviction, every negotiated plea. Defense lawyers will file motions regarding undisclosed evidence. They'll request disclosure of DOJ wrongdoing as potentially favorable to the defense. Some convictions may be overturned. If you are harmed by a federal crime, your case might be impacted. I'm not aiming to alarm you. This is the current legal reality. Practical measures. What knowledgeable individuals are currently undertaking. Checking investment portfolios for exposure to the involved companies. Monitoring statements from their state pension managers. Consulting financial advisors about municipal bond holdings. Questions for a professional. Does my retirement account contain holdings in any companies that have deferred prosecution agreements with the DOJ? If those agreements are invalidated due to prosecutorial misconduct, those companies face different liabilities. Knowledge helps you prepare. How did Bondi reply? She made the situation worse. Honestly. Sunday morning, her initial public comment following the charges. I have complete confidence in the Department of Justice and its dedicated public servants. Any suggestion of impropriety is politically motivated nonsense. That's the full statement. All of it. The reaction. The hashtag Bondi resign trended for 14 hours. 3 Republican senators remained quiet. No defense offered, no remarks. The White House released a single-line statement. The president supports his attorney general. No specifics. No factual defense. Just backing. Senate Democrats reacted strongly. Complete confidence in officials she just witnessed being indicted. That's not confidence. That's complicity. Senator Durbin, the senior Democrat on the Judiciary Committee. Then Monday occurred. Bondi canceled 2 planned public events. No reason given. Her personal lawyer, not the Justice Department counsel, her private attorney, submitted a request to the court to participate in the case, aiming to restrict what cooperating witnesses can disclose about interactions with high-ranking department officials. That's not the behavior of someone with nothing to conceal. Former associates noticed. 3 individuals who worked with her in Florida spoke to CNN. This isn't the Pam we recognized. Something has altered. The situation isn't diminishing, it's intensifying. What remains uncertain? 1. How the White House will react if charges broaden. Will Trump maintain support? Past behavior suggests yes, until it becomes politically damaging. 2. What the cooperating witnesses are aware of. The 3 charged officials have decades of cumulative DOJ service. They're aware of all sensitive information. What's coming next? The House Oversight Committee has scheduled urgent hearings for Friday, February 27th. Whitmore is anticipated to testify under a grant of immunity. The Bureau's concurrent investigation reports to a special prosecutor appointed discreetly 2 weeks prior. Name: David Weiss. Yes, that David Weiss. Bondi's legal team submitted a request for rapid judicial review of the AG as aware proof. A hearing is set for Thursday. Key dates: Thursday, February 26th, evidentiary hearing in federal court. Friday, February 27th, House oversight testimony commences. Monday, March 2nd, deadline for DOJ to release additional files under judicial directive. We should have more information by week's end. However, if Whitmore cooperates completely and provides detailed testimony, this advances to a different stage. Grand juries are already impaneled, the same one that issued Saturday's charges. Subscribe now. I will analyze each development as it occurs. This situation is progressing faster than most news organizations can manage. When the subsequent legal document emerges, I'll analyze it similarly. Hit subscribe, enable notifications. Our current position: 3 senior DOJ officials accused of federal obstruction. All 3 are engaged in plea agreement discussions as of yesterday. Pam Bondi remains Attorney General. No personal charges against her. An FBI investigation is active and broadening. Special counsel David Weiss supervises grand jury activities. Congressional hearings begin Friday. Scheduled for Thursday, February 26th, federal court hearing on proof admissibility. Friday, February 27th, House Oversight Emergency Session, Whitmore testifies. Monday, March 2nd, court-mandated document release deadline. March 3rd to 7th, expected grand jury meetings. Not yet officially announced. At least 2 additional DOJ employees have reportedly been contacted by investigators. Their status, whether as witnesses or targets, is unclear. The Delaware data server, the one that was erased, is in FBI forensic custody. The success of data recovery is unknown. And there's one additional detail. A 4th individual is mentioned in the legal document. The name is blacked out, labeled co-conspirator A. Prosecutors don't redact names of cooperating witnesses. They redact names of individuals they are still constructing cases against. The timeline is constrained. That's our current position. Pam Bondi, still in her position, but surrounded by a widening investigation. A superficial view suggests subordinates are facing charges while she remains untouched, but her name appears on those emails, 17 of them. Her personal attorney is attempting to restrict witness statements. Her public defense has been a single sentence over 3 days, and 3 officials with nothing to lose are currently negotiating cooperation agreements. I will be observing Thursday's hearing attentively. The court's decision on proof dictates what prosecutors can utilize moving forward. If the AG is aware message is permitted as evidence, this situation accelerates. If it is excluded,